If you're facing probate here in California, here's the question that keeps people up at night. What is this actually going to cost? And the honest answer surprises almost everyone, because in California, many of the biggest probate fees aren't negotiable. They're set by law based on the size of the estate. I'm Shanty Soerjono with eXp Realty. I specialize in probate and trust real estate here in California, and I walk families through this every single week. Before we go further, one important thing. I'm a real estate specialist. I'm not an attorney, I'm not a CPA, and I'm not a financial advisor. Everything here is general information to help you understand the process. It is not legal, tax, or financial advice for your situation. For that, please work with a licensed probate attorney and a tax professional. Probate has a whole stack of costs. Some are small and fixed. Some depend on your estate. And two of them, the big ones, are set by a state formula. Let me walk you through all of it using a $900,000 estate as our running example. It starts when you file the petition for probate with the Superior Court. That filing fee runs around $435 to $500, depending on your county. Once the court appoints the personal representative, you'll need certified copies of the letters testamentary, or letters of administration to work with banks and title companies. Each copy is a small fee. California also requires you to publish a notice in a court-approved newspaper, and that's usually $200 to $600. Then, most estates need a court-appointed probate referee to appraise the non-cash assets. Their fee is 0.1%, that's 0.1% of what they appraise. So on an $800,000 property, that's about $800. Now the big ones. In California, attorney fees for probate are set by statute, are literally written into law as a percentage of the gross value of the estate. It's a sliding scale, 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and it keeps stepping down from there. So on our $900,000 estate, 4% of the first 100,000 is $4,000. 3% of the next 100,000 is $3,000. And 2% of the remaining 700,000 is $14,000. Add those together, and the attorney's statutory fee comes to $21,000. Here's the part that stuns people. The personal representative, the executor or administrator, is entitled to that exact same statutory fee, another $21,000. So on this one estate, those two fees alone add up to $42,000. The good news, the personal representative can choose to waive their share, and a family member serving in that role often does. Beyond those statutory fees, a probate picks up other costs too: extraordinary fees, a possible bond, CPA fees, the home's carrying costs, and creditor claims paid before anyone inherits. But here's the single most important thing about California probate fees, and it catches almost every family off guard. The statutory attorney and representative fees are calculated on the gross value of the estate. Gross, not the equity. Picture this. The home is worth $1 million, but it still carries a $700,000 mortgage. Your real equity is only $300,000. But California doesn't look at the mortgage. For those fees, that home counts as a full $1 million asset. So you can owe fees on value the estate doesn't really have. That's exactly why so many families set up a living trust, to keep the home out of probate and skip these fees. So yes, probate can be expensive, but these costs are set by law and paid from the estate, not from you. One more time, this is general information, not legal or tax advice. And if you're a spouse, an heir, or an executor in California with a house in the estate, I offer a free, no-pressure consultation. I'm Shanty Soerjono with eXp Realty. You don't have to figure this out alone.